Chapter 2, Alternative Dispute Resolution in India, ADR, Notes and Summary from Class 12th, Subject Legal Studies. Introduction. The justice delivery system aims to resolve disputes in a fair, efficient and timely manner. Traditionally, courts have been the main forum for dispute resolution. However, due to increasing litigation, delays, high cost, and procedural complexities, courts face immense pressure. To address these challenges, alternative dispute resolution ADR mechanisms have been developed. ADR provides non-adversarial, flexible, cost-effective and speedy methods for resolving disputes outside traditional courts. India has a rich tradition of dispute resolution through community elders, panchayats, and informal negotiations. Modern ADR mechanisms have statutory backing and judicial recognition, making them an integral part of the Indian legal system. First, adversarial and inquisitorial systems. Legal systems across the world broadly follow either the adversarial system or the inquisitorial system. In an adversarial system, the dispute is between two opposing parties. Each party presents its own case with evidence and arguments. Lawyers play a dominant role in presenting and contesting evidence. Cross-examination is a key feature. The judge acts as a neutral and passive umpire. The decision is based solely on the evidence produced by the parties. Countries following this system: India, United Kingdom, United States, Australia, common law countries. In an inquisitorial system, the judge plays an active role in investigating the case. The judge identifies issues, collects evidence, and questions witnesses. Lawyers have a limited role. Cross-examination is minimal or absent. The focus is on finding the truth, not just winning the case. Countries following this system: France, Germany, Italy, civil law countries. Second, advantages and disadvantages of adversarial and inquisitorial system. The main advantages of an adversarial system include: effective cross-examination helps test the credibility of witnesses. Parties feel satisfied as they have control over presenting their case. Judicial neutrality ensures fairness, suitable for protecting individual rights and liberties. The disadvantages of an adversarial system are the following. High cost of litigation creates inequality between rich and poor litigants. Over-dependence on lawyers leads to delays. Procedural complexities prolong trials. Judges are not duty-bound to discover the truth independently. Justice may suffer if evidence is poorly presented. The main advantages of an inquisitorial system include: faster disposal of cases due to active judicial involvement, reduced procedural delays, greater equality between parties, focus on truth finding rather than technicalities. The disadvantages of this model include: risk of judicial bias due to investigative role of the judge, excessive burden on judges, limited scope for party participation, may reduce transparency in decision making. Third, introduction to alternative dispute resolution, meaning and scope. Alternative dispute resolution ADR refers to methods of resolving disputes outside the traditional court system using non-adversarial techniques. ADR includes arbitration, mediation, conciliation, lok adalat, ombudsman, lokpal and lokayukta. ADR focuses on speedy justice, mutual settlement, reduced hostility, preserving relationships. Section 89 CPC Settlement of Disputes Outside the Court. Section 89 of the Code of Civil Procedure 1908 empowers courts to refer disputes for settlement outside court when elements of settlement exist. The court may refer disputes to: first, arbitration, conciliation, judicial settlement including lok adalat, mediation, Objective: reduce pendency of cases, encourage amicable settlements, promote access to justice. Fourth, problems faced by courts. Indian courts face several systemic challenges: huge backlog of cases, inadequate number of judges and courts, high litigation costs, procedural delays, increasing population and legal awareness, complex and outdated laws. These problems necessitate effective alternatives like ADR. Benefits of ADR: ADR offers multiple advantages over litigation: faster resolution of disputes, cost-effective mechanism, informal and flexible procedures, confidential proceedings, parties choose time, place and neutral, preserves relationships, technical experts can be appointed, reduces burden on courts, greater satisfaction and voluntary compliance. Opinion: ADR isn't just an alternative anymore for commercial and civil disputes, it's honestly the smarter first choice. Types of ADR: A. Arbitration. A1. Introduction. Arbitration in India is governed by the Arbitration and Conciliation Act 1996. Based on the UNCITRAL model law, it provides for domestic and international commercial arbitration and enforcement of arbitral awards. A2. Meaning: arbitration is a private dispute resolution process where parties agree to submit disputes to a neutral third party called an arbitrator, whose decision is binding. A3. Process of arbitration. First, notice of arbitration. Aggrieved party initiates arbitration. Appointment of arbitrator chosen by parties or court. Statement of claim filed by claimant. Statement of defense. Counterclaim filed by respondent. Hearings and evidence, confidential proceedings. Arbitral award, final and binding decision. A 3.1. Setting aside of an arbitral award. An arbitral award may be set aside on limited grounds such as invalid arbitration agreement, bias of arbitrator, lack of proper notice, award beyond scope of agreement, violation of public policy. A4. Types of arbitration: domestic arbitration, foreign arbitration, ad hoc arbitration, institutional arbitration, statutory arbitration, international commercial arbitration. Bharat Aluminium Company Limited versus Kaiser Aluminium 2012 SC. Key principles laid down. Seat of arbitration determines applicable law. Indian courts have no jurisdiction over foreign seated arbitration. Arbitration Act applies only to arbitrations seated in India. This judgment strengthened India's image as an arbitration friendly jurisdiction. B. Mediation. B1. Meaning and types. Mediation is a voluntary process where a neutral mediator facilitates communication to help parties reach a mutually acceptable settlement. Types of mediation: evaluative mediation, facilitative mediation, transformative mediation, mediation arbitration, online mediation. B2. Process of mediation: appointment of mediator, opening settlements, opening statements, joint discussion, private caucuses, negotiation, settlement agreement. Outcome is non-binding unless converted into a contract. C. Conciliation. C1. Concept. Conciliation involves a neutral conciliator who actively suggests settlement terms. It is less formal and more flexible than arbitration. Governed by Arbitration and Conciliation Act 1996. Settlement agreement has legal status of arbitral award. D. Lok Adalat. D1. The benefits of Lok Adalat include speedy justice, no court fees, simple procedures, final and binding decisions, no appeal, promotes compromise and harmony, established under Legal Services Authorities Act 1987. F. Ombudsman. about banking and insurance ombudsman, appointed to resolve consumer grievances, deals with complaints against banks and insurance companies, provides inexpensive and quick redressal. Decisions are binding on institutions. G. Lokpal and Lokayukta, anti-corruption institutions. Lokpal at central level, Lokayukta at state level, investigate corruption complaints against public officials, established under Lokpal and Lokayuktas Act 2013. Summary: Alternative dispute resolution plays a crucial role in ensuring access to justice in India. It complements the judicial system by offering efficient, flexible, and people centric solutions. ADR mechanisms reduce court burden, promote settlements, and strengthen trust in the justice delivery system. My honest opinion: if courts are the heart of justice, ADR is the pressure release valve. Without it, the system would collapse. So friends, we have completed notes and summary of chapter 2, Alternative Disputes Resolution in India, ADR. We will do question answers of this chapter in a separate video. If you like the video, kindly like, hype the video and share it with your friends. Also subscribe to my channel and press the bell icon to receive new video notifications. We will meet in the next video. Thank you for watching.